I think we might usefully make a start. We've got a number of attendees who've logged in already. Can I welcome you all and begin with two acknowledgements? The first is just a virtual acknowledgement for all the people across a number of continents that are logging in to express the respect for the rights of all the various First Nations peoples to the lands across the continents where we meet virtually. The second acknowledgement is to thank all of those who've made this event possible. It's going to be a very exciting hour, and we have an exceptional panel of Australian and Canadian panellists who are going to delve today into the detail of Dr. Daly's new book, Understanding Administrative Law in the Common Law World. Personally, can I also say what a delight it is to be able to moderate the panel discussion of this outstanding book. I'd like to begin the discussion just with a few brief remarks about the role of books like this in our courts, and particularly in ultimate appellate courts. But before I commence, can I just say that if during the course of this seminar people have any questions, if you could just write down or take a note of them, and if there's time at the end, I'll moderate any questions that people have for Dr. Daly. Can I start then just by saying that most of the cases, at least in the High Court of Australia, are appeals that come by a process of leave, which in Australia is called special leave to appeal. The central issues that the High Court of Australia decides when deciding to grant special leave will include whether the matter raises a question of law that's of public importance, and whether there are differences of opinion in Australian courts about the state of the law. Similarly, in the High Court's original jurisdiction, a consideration of whether to remit a matter to lower courts will be whether the matter raises a question of national public importance that requires the High Court to hear it at the first instance. What this means is that the diet of cases in the High Court of Australia, like those in the Supreme Court of Canada, almost invariably raises questions which require the court to consider whether a legal rule should be expanded, contracted, abolished, or restated. In some cases, it's not even clear what the rule is. But in almost every case, it's necessary for the court to consider the underlying foundations for the legal rule that's been raised. That requires usually consideration of the history and development of the rule, as well as its justifications as a matter of principle. This latter area particularly is the area where the partnership between the courts and the academy is so important. An ultimate appellate court, like the High Court of Australia or the Supreme Court of Canada, will usually hear between about 50 and 70 cases a year. That means that judges will have less than a full week of thought to devote to every case. Leading academic writers in the field might have devoted 40 years to consideration of an issue that an appellate judge has several days to resolve. For that reason, good and clear academic writing which deals with and explains the deep underlying issues underneath various rules is essential to our everyday task. I ideally hope that the days are now past in which a judge might deride an argument as academic or dismiss an academic work as impractical. The quality of the work product of any ultimate appellate court is heavily dependent upon academic work of powerful theoretical import. Sometimes, particularly in criminal law cases, where the resolution of the appeal might be relatively easy and the profession would benefit from a simple and clear statement of a rule, the reasons for decision will be short and decisive. But like a duck's feet underwater, there will almost always have been a great deal of unexpressed thinking and discussion that's not reflected in the written reasons. On other occasions, it's necessary to expose deeper thinking. A recent example in the High Court of Australia is the statement of the doctrine of materiality in administrative law. For decades, the High Court of Australia endorsed what's been described as Professor William Wade's conception of the foundations for limits of statutory powers of decision makers. And that conception is that the foundations lie in unexpressed statutory implications. Hence, it's commonly held to be implied in a statute that a broad power conferred on a decision maker will have been invalidly exercised if the decision maker exercises the power unreasonably, or for purposes or by reference to considerations that are outside the scope of the statute. In a case called Hussain and Minister for Immigration, The High Court, in a number of separate judgments, also recognised there will usually be an implication that immaterial transgressions of these limits will not lead to invalidity. It's fair to say that the recognition of this implication by the High Court of Australia was not an immediate success. Lower courts, for example, didn't know who bore the onus of proof for this doctrine. In criminal law, the answer had been settled for half a century, and the answer was that it was for the respondent, the Crown, to prove. In my view, the issue had also been resolved for more than half a century in relation to appellate review, again where it was for the respondent to prove. But ultimately, a majority of the High Court imposed the burden on the opposite party in administrative law. Two of my colleagues in dissent, Justices Gordon and Stewart, focused very heavily on the underlying issue of principle. What could be the principled foundation from which such an onus could be discerned? They relied, as I did, upon powerful work of academics in this field, including some of today's panellists. They quoted in particular from Dr. Daly, who had remarked in 2019 that, and I quote, "Whereas one might be content to accept that the applicant bears the onus of proof generally in judicial review cases, one might nonetheless consider that putting the onus of proving materiality on the applicant doesn't adequately ensure that administrative decision makers will comply with the law." The problems for the materiality implication didn't stop with onus. It wasn't always clear for lower courts even what the High Court had meant by materiality. When this issue arose in a different case concerning the scope of the rule against bias, I turned again to the writing of Dr. Daly to untangle three different senses in which materiality is used. In this area, as Dr. Daly explained, materiality involves a connection between administrative justice and the ultimate decision. An administrative injustice will commonly be intended by Parliament to be immaterial and not capable of invalidating a decision if it didn't involve a fundamental departure from the proper process of decision making and if there was no possibility that the decision would have been different. But untangling these different senses still leaves deeper questions. Why is an implication of materiality made at all? The immediate answer, consistent with William Wade's theory of administrative law, is that this is what a reasonable person reading the statute in its context as part of the matrix of our legal system would understand the legislative provision to require. But apart from matters of legal history concerning materiality, what are the values that that reasonable person would bring to this understanding? To use the expression of Dr. Daly in his book, what are the plurality of values that guide our understanding, that justify contemporary administrative law, and that explain this feature of administrative review? It's in providing this path to answering difficult questions such as this that understanding administrative law in the common law world is such a valuable and outstanding work. It provides a deep, reflective approach to administrative law that establishes the foundational values that guide the principles which themselves form the basis for the understanding and development of administrative law rules. Others are going to say a lot more this morning about the content of Dr. Daly's book. Can I just add one final point about its methodology by way of unequivocal endorsement? Dr. Daly describes his book as a work which is iterative, beginning in the identification in the abstract of a value, capable of explaining the decided cases, but then modifying the abstract definition of the value to ensure that it better fits the particularities of the decided cases. As a former colleague of mine put this Dworkinian point a little more pithily, sometimes after you have read a judge's reasons, you might frown a little, spend a lot of time reflecting on the issue, and then carefully explain to the judge precisely why it is that, despite their reasons, their answer might be right. And on that note, I'll call first upon Dr. Daly to give a 5-minute overview of his book. Dr. Daly, as many of you, if not all of you, will know, is the University Research Chair in Administrative Law and Governance at the University of Ottawa. He's also a part-time member of the Environmental Protection Tribunal of Canada, and his book, as I've said, Understanding Administrative Law in the Common Law World, offers a new framework for understanding judicial review of administrative action. Over to you, Dr. Daly.
Well, thank you very much, Justice Edelman, for that very kind and indeed delightful introduction. I should start, I suppose, by explaining why I decided to write the book. And the impetus really was to create a readable framework, an overview of the very diverse range of areas which we call administrative law, ranging from procedural review to substantive review, remedies, scope of review, and so on. Areas which are often studied, taught and argued about in silos. But I'd come to perceive that there were significant commonalities across these areas, unifying themes, unifying forces. Now, this was true not just in the jurisdictions I was most familiar with, Ireland, Canada, and in England, but also in Australia and New Zealand as well. In particular, there had been an explosion of growth in the general principles of administrative law since the procedural and judicial reforms of the 1960s and 1970s. This was a set of general principles, I thought, which was a very useful set of principles, which was dynamic and responsive to the many challenges that evolutions in public administration had thrown up. And so I was also concerned not only to provide a readable framework, a readable entry point into the subject, but also to defend the legitimacy of what the judges had been doing against some criticism. And the framework I develop is a framework which is based on 4 values. The first value is individual self-realization. And the idea here is that judges, in creating administrative law doctrine and in deciding cases, should further the autonomy and dignity of individuals. That is to say, in prosaic terms, they should help individuals plan their affairs and ensure that they're treated with concern and respect by the state. The second value is good administration. And here, I'm interested in judicial solicitude for effective and efficient use of scarce administrative resources by the state. The third value is electoral legitimacy. The idea here is that judges should respect the mandates of those who have run an electoral gauntlet, be they sitting in a legislative assembly or a municipality or exercising adjudicative or discretionary powers. The fourth value is decisional autonomy. And the idea here is that distinct bodies should play distinct functions. To an Australian audience, legality is for the courts, the merits are for the executive. Now, sometimes these values function in a complementary fashion. And an example of this is the right to reasons in administrative law. The starting point sounds in good administration. There is no general duty to give reasons, because otherwise it would gum up the works of public administration. But there are exceptions to this starting point, which sound equally in administrative law values. Where a decision is very important to an individual, reasons should be given. Individual self-realization, I would say. Where there is a statutory appeal and the right of appeal requires reasons, for otherwise it would be nugatory, well, that sounds, I say, in electoral legitimacy. Reasons need also be given in situations where they're necessary to permit the courts to perform their reviewing function. Again, decisional autonomy, I say. Sometimes a balance has to be struck between the values and judges have to bring them into equipoise. I would say procedural fairness is a nice, simple example. If we were to push the logic of individual self-realization to its logical limits, then individuals would be entitled to full trial type procedures in all cases, in all situations. But we don't do that because to do so would be to frustrate effective and efficient public administration. So sometimes complementary, sometimes in equipoise, and the traction of these values may differ from area to area. When we go to the scope of judicial review, what is subject to judicial review, they have a very direct impact on how judges handle individual cases. In other areas, like procedural fairness and substantive review, they operate at a slightly higher level, structuring the general doctrines in the area, not necessarily having as much traction in individual cases. And I would say this is true of Commonwealth jurisdictions generally. Australia, Canada, England, Ireland, and New Zealand are the systems I study in the book. And I study the core features, I say, of administrative law in these jurisdictions. Institutional review, the rule against bias, Carltona, fettering, etc. Procedural fairness, substantive review, remedies, restrictions on remedies, exhaustion principle, privative clauses, the scope of review, and legitimate expectations. Across all of these areas, the values of individual self-realization, good administration, electoral legitimacy, and decisional autonomy recur and provide a framework for understanding and justifying the law. And just to conclude, I will say that this is, as Justice Edelman indicated, it is an interpretation, a Dworkinian interpretation. I'm not looking to describe what the judges actually did in a particular case. Their reasons for deciding a case might be very different from the reasons that I'm imputing to them later on. But this is the essence of an interpretive framework, telling the judges what they should have thought rather than what they actually did think. So thank you very much to the Gilbert and Tobin Centre and the Public Law Centre here for having me. And thank you, Justice Edelman and my esteemed colleagues for agreeing to participate.
Thank you, Dr. Daly, for that excellent introduction. The first commentator that we have on the panel is Dr. Bowie, who's a senior lecturer in the University of New South Wales Faculty of Law and a member of the Gilbert and Tobin Centre of Public Law. She holds a PhD from Monash University and an LLM in Government Law from the Australian National University, and undergraduate degrees in Law and Economics from Sydney University. She teaches and researches in Australian, Canadian, and United Kingdom public law, and focuses her work on the interaction of human rights and judicial review of administrative action along with other topics in public law. Her work has been particularly useful in the courts, and we welcome her as the first commentator. Dr. Bowie.
Thanks so much, Your Honour, for that very kind introduction. I want to acknowledge the traditional owners of the land that I'm joining you from today, the Guringai people, and pay my respects to their elders past and present. And also thank you to Paul and the University of Ottawa Public Law Centre and to Vanessa for the opportunity to share some of my thoughts on Paul's excellent new book in this forum. I'm going to focus my comments on chapter 4 of the book, which examines substantive review. That includes the principles governing the intensity at which courts will scrutinise administrative decisions, encompassing the division between jurisdictional and non-jurisdictional error, one of my all-time favourite topics, rationality or reasonableness, and relevancy and propriety. Now, the reason I have chosen to focus my comments there is because I think the book's analysis is revealing in explaining the values driving some of the recent Australian developments in unreasonableness and the addition of a materiality threshold for jurisdictional error. There's been a lot of academic and some judicial articulations of the values which underpin judicial review of administrative action. They all share a lot in common, but often use different labels. I think that Daly's 4 values of individual self-realisation, good administration, electoral legitimacy, and decisional autonomy are a particularly neat way of describing these values. And as the book argues, I think they're very helpful in explaining the rationales for and shifts in the way courts approach substantive review. So I'll start with the divide between jurisdictional and non-jurisdictional error, which, as Daly acknowledges, has had different meanings and uses over time and in different jurisdictions. The book explains that the value of electoral legitimacy justifies judicial intervention when decision makers step outside the bounds of their authority, but that it equally explains that the legislature has made deliberate choices to leave certain matters to administrators. Decisional autonomy as a value provides further support for the latter, whereas good administration and individual self-realisation demand that there be some judicial check on discretion, and the latter in particular, individual self-realisation, suggests that where a particularly important or vulnerable right is at stake, courts should be perhaps more willing to intervene. Daly explains materiality in this context as follows. Only serious error, which undermines the statutory scheme or interferes with individual rights or other legal values, will be treated as having invalidated the decision, whereas a relatively immaterial error will not invalidate the decision. Invalidity, after all, would have significant administrative consequences and risk frustrating good administration. In other words, a materiality threshold for invalidity can be seen as protecting the values of good administration and decisional autonomy. Judicial intervention is still required, though, to protect breaches of law which go beyond what Parliament has clearly authorised and to protect especially significant individual interests. And I'd make two further points about the recent addition of a materiality threshold for jurisdictional error in Australia based on this analysis. First, I think that it offers a more helpful explanation than one based on legislative intention alone. While there's certainly some precedent to support the threshold in the context of jurisdictional error, it involves some cherry picking of precedent. And the threshold to me is quite clearly a in Australian law. As some commentators have argued, including my brilliant colleague, Dr. Lisa Crawford, legislative intention alone is not a sufficient and convincing rationale for it. Values quite clearly underpin the presumptions that courts attribute to Parliament, even if Australian courts don't tend to articulate those values, they're there. And Daly's account, I think, is a very helpful illumination of the way the Australian High Court has rebalanced core administrative law values in introducing a materiality threshold. Secondly, I'd like to emphasise one of the limits on materiality from Daly's account, that the value of individual self-realisation where important rights are at stake should not give way to decisional autonomy and efficient administration. Individual self-realisation, I'd add, goes beyond substance. Treating individuals with respect and concern in the process of decision-making remains an important element of the value, even if what the individual has to say can't change the outcome. Daly's account of values is equally helpful, I think, in explaining another recent shift in Australian law, that is the shift in the reasonableness threshold. Again, there was initially little acknowledgement amongst the High Court in Lee that this was even a shift, let alone an explanation for it. But the resurgence of the ground and the amount of case law on it shows that it clearly was. And it was quite a significant one. Cases since Lee have refined the threshold of legal unreasonableness so that it now comes closer to the approaches in other common law jurisdictions, including those which Daly examines in his book. That is, as he explains, it's a context-specific variable standard which focuses on the justification provided by the decision maker when one is provided. And again, most of the court's explanations of the standard have centred on legislative intention. And certainly this provides an account of some elements which demand variability, for instance. The new focus on justification, however, reflects decisional autonomy and good administration. And what I think is missing from Australian accounts, and what I'd like to add, is how intimately connected the shift in Australia's reasonableness standard has been to the value of individual self-realisation. It's largely occurred in the migration context, where there's been a long-running battle between Parliament and the courts over the extent to which procedural fairness can be limited by statute. The Migration Act places significant limits on procedural fairness by setting out detailed codes of procedure, which in relation to certain decisions, including fast-track reviews, the Act provides an exhaustive statement of the requirements of the Natural Justice Hearing Rule. And this was the context in which Lee was decided. Ms. Lee originally sought review on the ground that the tribunal's refusal to adjourn and proceed to make an adverse decision had denied her a fair opportunity to present her case. The minister responded that the relevant provisions of the Migration Act constituted an exhaustive statement of the requirements of the Natural Justice Hearing Rule and had not been breached. And this raised difficult interpretive and potentially constitutional questions about Parliament's power to restrict the content of the Natural Justice Hearing Rule and authorise decision makers to act in a way which denies natural justice to an applicant. And these were complicated by the complexity of the legislative framework of the Migration Act, which includes provisions which appear on their face to contradict the apparently clear legislative intention exhibited by exhaustive statement provisions to limit procedural fairness. But most of the judgments from first instance to High Court appeal avoided these issues by finding that the refusal to adjourn had been unreasonable. Most of the unreasonableness cases since Lee have also dealt with discretionary process decisions. And what I mean by a process decision is the exercise of a discretion as to how to conduct a review. So decisions like in Lee not to adjourn a hearing, or not to seek further information from an applicant, or not to invite an applicant to a further interview. So now, as Justice Edelman put it in ABT 17, there are two categories of unreasonableness, one process focused and the other outcome focused. And the extension of unreasonableness to process decisions might not have been absolutely necessary to resolve Lee, as the Chief Justice's reasoning in that case shows. It's proven to be a really prescient development. The provisions of the procedural code in the Migration Act, which deal with the fast track process, are explicit about the exhaustiveness of their operation in the fast track process. And the extension of unreasonableness to process discretions means that these decisions are not islands of power immune from supervision and restraint. So the shift manages to protect the value of individual self-realisation without pushing back on the value of electoral legitimacy. And the final point I just wanted to mention in wrapping up is that the High Court is famously, perhaps infamously, reluctant to explicitly engage with values on the whole. There's definitely some exceptions. And I just emphasise that this doesn't mean the values aren't there, that they're there in underpinning the presumptions attributed to Parliament, including in those cases that I've just discussed. But they're rarely made explicit. And I think it's a worthy question of whether there might be benefits in being more explicit and transparent judicial engagement with values in judicial reasoning. And Daly's book does much of the hard work in carefully defining and dissecting those at play in the administrative law context. Thank you.
Thank you very much, Dr. Bowie, for an outstanding presentation. We'll move straight on to the next one. Next speaker who is Dr. Knight, who's an associate professor at the Faculty of Law at the Victoria University of Wellington. He holds a PhD from the London School of Economics and Political Science, an LLM from the UBC in Canada, as well as an LLB and a BCA from the Victoria University of Wellington. He specialises in public and government law with scholarly interests of topics in constitutional and administrative law. We look forward to his presentation. Thank you.
Thank you, Justice Edelman. And kia ora koutou, folks. I bring greetings from Aotearoa, New Zealand, ngā mihi nui, and I'm very grateful for the opportunity to join in this this panel today. So where do I start? Perhaps I should start with a confession. I was never any good at languages. And I dodged them in my study years. So while my schoolmates were doing French and German, I was doing hardcore economics and calculus. And the same goes at university, where I grew up in the faculties of law and commerce, away from the corridors of modern languages or te reo on the pai. But Paul's book reminds me that as administrative law scholars, we are disciples of language. And Paul is a missionary of the highest order. And I want to explain that. Because when I was taught judicial review, I was taught as a study in doctrine. rules, grounds, remedies, the cases that explain and apply them. And I think you all know that way. It's that classic English public law tradition that as I think Harlow and Rawlings describe it, that sort of close semantic study of their cases, assessment of consistency with precedent and so forth, and predictions what might happen next and so forth. But to be honest, that's not really how I think about judicial review nowadays, and I'm not sure many of us in the room do either. For me at the moment, with my present mood, I think of it in terms of dialogical accountability. It's a conversation. It's a very human conversation. It's a conversation where an actor, be it a minister, an official or public body, is called on to render account. And a forum, a court, a supervisory court, that interrogates that explanation through questioning and analysis and passes judgment by expressing its appraisal publicly, and consequences may flow from that. And here I'm borrowing that relational definition of accountability that we know from Bovins. But I think it might be helpful to think about that as an exercise in or some form of dialogue. And it's a conversation, I think, where language, where the words and the rhythm matter. And that's why I'm so excited about Paul's book, because Paul cares about the language that frames the accountability conversation. And in his book, he reveals the lexicon from that existing messy discourse. That's the interpretive method, as he's already explained to us before. And thirdly, I think most importantly, he gives us, and I think importantly, he gives public actors, courts, a dictionary or a phrase book that shapes that rendering of account and the exaction of the appraisal. That's I think as he describes it as a sort of lightly normative ambition, but I actually think there's a lot more weight in what he's doing here, in the way that he wants to nudge, rightly, the way accountability is rendered. Now, I know Paul explains his project in terms of values, but I do think there is virtue in thinking about his work as a study of linguistics, the linguistics of judicial review. And so in the time I've got, I want to briefly nod to two things. I want to start by just opening up and recording that sort of faux linguistic game that plagues some aspects of our discipline currently. And then I want to move and suggest how Paul's value-based approach, his new dialect, allows us to transcend that quagmire. So the now question. We've probably all got our own examples of where there's been a spat about the language of doctrinal rules or supervisory principles. Here in New Zealand, it's deference. Deference is the word of the devil. And variable intensity is another phrase that polarizes senior judges. So deference, in the words of our former Chief Justice, is in quotes, a dreadful word. Variable intensity for other judges is synonymous with terminological overload, misleading concepts, a distraction, a perversion, dancing around on the heads of pins, an intensity of anxiety. And many judges just can't bring themselves to use these terms, even though it's the lexicon of the lecture theatres of Victoria University, but we'll see. Judges can't bring themselves to use these terms, yet they regularly deploy the substance of these concepts in their appraisal of government decisions in that accountability conversation. Justice Francis Cook is one example, and he has recent form on this, and he won't mind me saying this because we engage on this quite a lot. He just couldn't bring himself to speak in terms of deference when assessing the science relating to vaccine mandates in a decision in the last month. Instead, as he put it, there is a limit on the court's ability to address the issues in an evidential sense. Forensic limits, as he put it, forensic limits on what the court can do. In another case earlier, while rejecting variable intensity in favour of a singular focus on legality, he declined to assess whether ammunition prohibited by ministers was insufficiently harmful to qualify restriction on the grounds that the courts were ill-equipped to undertake that appraisal, and it was a question better left to expert officials and ministers. Now, if that isn't deference, I don't know what it is. And I could go on. And I could also, I guess, nod to that linguistic ritual of jurisdictional error and legality merits Nina's already painted a picture of that in the way that it creates that dissonance between lexicon and practice in the Australian administrative law. And the key point is that the language of the doctrinal appraisal often does not match the essence of the the language of the doctrinal analysis often doesn't match the essence of the functional appraisal in our accountability dialogue. And I think that risks an inauthentic accountability conversation where justification offered and appraisal is exacted in some form of foreign code. Hence, we welcome Paul's interpretive project and his dictionary for accountability. Individual self-realization, good administration, electoral legitimacy, decisional autonomy, if I got that right, Paul, and the worked out explanations of the essential concepts and values that are similarly vivid. I should pause and say, thankfully, he eschews any meta value or meta principle, a singular slogan or billboard such as abuse of power. That would just amount to shouting. It would be inapt for the richness of conversations about accountability. As he explains, accountability is not a mechanistic exercise where matters under scrutiny are dropped into a black box and a result spits out, nor is it a formulaic exercise where rigid rules are applied and a summative answer is produced. As I say, it suggests it's a conversation that's conditioned by constitutional institutional dynamics in the context of situated concerns about individual justice and good governance. And that rings, I know Paul and I are 100% in agreement, that's the terrain on which these conversations take place. And as we know, it's the common law courts who are responsible for generating the language that animates that conversation. And Paul's lexicon empowers the courts to rise to that task, rising above the minutiae of illusory doctrine, but avoiding the vices of palm tree justice. So as Paul explained himself, he's explained the structure of duty of fairness in terms of those important values and so forth. And you'll hear more from, you've heard some from Nina, and Narella will also chip in the way that they're deployed. My point is that the language helps organise the conversation about accountability, both in terms of the delivery of that justification and the process of appraisal. It reorientates the dialogue to what's actually at stake in our supervisory jurisdictions. In other words, it renders explicit what is implicit in the language of our discipline. It spells it out, if I can add, revealing the duck feet. Now, this shift to values and this proposed new language, I think, is faithful to the developmental arc of judicial review of administrative action too. Stanley De Smith, in his 1959 textbook, was one of the pioneers of this type of project, digging out, revealing, and explaining the morass of doctrinal rules in play in the mid-20th century. Our first coherent dictionary and phrase book of judicial review of administration. And we can see the language shifts in his own textbook over its various editions, as I've narrated in my own work. It's not a pitch, but I'm just, it's a tradition, from scope to grounds to intensity to context. So too do we remember the work of our famous administrative linguists in the early 1980s, Lord Diplock and Lord Cook, as they reframed judicial review as sets of tripart general principles, now canonised in some of the jurisdictions within our common law family, perhaps not all of them. And I see Paul's work as continuing that endeavour, moving up a conceptual notch or two. So I guess we should ask, will his turns of phrase, his lexicon be canonised like the tripartite grounds or chapter headings? Time will tell, I think. For myself, I see merit in the core values expressed and agree with the worked out explanations of how this reflects the reality of judicial review as a form of dialogical accountability. Part of me dwells on footnote 91 in chapter 1, though, where Paul defends his shift from the more familiar labels to the current bespoke set we see. That might be a necessary turn to escape the baggage that comes with the earlier working language of rule of law, democracy, separation of powers. We'll see how Paul's language resonates with others and the extent to which it is successfully co-opted, and I hope it will be. In any event, this is a space where we need wise interpreters like Paul, and we need phrase books like this wonderful text. Ka pai for your poetic words, Paul. Kia ora koutou. Thanks, everyone.
Thank you very much, Dr. Knight, and particularly for the reminder that language really matters. We'll go straight to our next presenter, Assistant Professor Narelle Bedford, who is an Assistant Professor of Administrative Law and Canadian Administrative Law at Bond University in Australia. She was previously employed by the Australian Attorney General's Department in the Administrative Law Branch, the Secretariat of the Administrative Law Review Council, and was also formerly an Australian diplomat. Can I also add that amongst her writing is outstanding research on the Australian Administrative Appeals Tribunal. Over to you, Professor Bedford.
Jingari Jimbalang. I'm joining you today from the lands of the Kumbameri Nation, where the rainforest and the mountains meet the glorious beaches fringed by the Pacific Ocean. I give my respects to the Kumbameri elders and First Nations people worldwide, and I commit to true reconciliation. The Kumbameri people speak Yugambeh language, and Jingari Jimbalang means hello friends. Comparative administrative law is a relatively recent and emerging field of academic study. Historically, I think it has tended to be viewed as a solely domestic discipline. There is now a growing number of scholars who encourage others to resist focusing on the differences that arise between nations in the evolution of administrative law. This approach would not emphasize Australian exceptionalism, for example. Instead, it seeks to analyse that which unites us rather than that which divides us. Professor Daly has made an important contribution through this book to our deeper understanding of the unity in administrative law. One visual image for what Professor Daly has done in his valuable contribution is to find a pathway through the forest of individual cases in the countries that he's focused on. This imagery of forests and individual cases has clear inspiration from Tennyson's wilderness of single instances. Procedural fairness, I think, can be susceptible to such reductionism. That is, that it's all dependent on the specific facts in each case. But to counter this is to look at its enduring nature and the strong existence of procedural fairness in each of the countries covered in Professor Daly's book. This means there must be some coherence and force to procedural fairness, and it is one of the best known and accepted beacons of administration. I've volunteered to speak on Professor Daly's book, in particular on procedural fairness, which is found in chapter 3, but honestly, it's woven throughout the entire analysis. To me, procedural fairness is one of the standout and consistent protections offered by administrative law, regardless of geography. Indeed, it spans across legal traditions beyond the common law world and is easily found to exist in civil law systems too. I wanted to rely on Professor Daly's book firstly as a platform to think about a potential future development in procedural fairness and to use his values-based approach to see how that might fit with this future development. And as procedural fairness continues to evolve, one area which will become increasingly important in a number of the countries included in the scope of Professor Daly's book, notably Canada, Aotearoa, New Zealand, and Australia, is the obligation to consult with First Nations people on any administrative decision that impacts on them. I think this aspect of procedural fairness can be better understood using the lens of the values-based approach advocated by Professor Daly. So as we've heard, the 4 values he identifies are individual self-realisation, good administration, electoral legitimacy, and decisional autonomy. Of greatest significance for First Nations consultation are the values of individual self-realisation and good administration. Individual self-realisation for First Nations peoples is in alignment with the United Nations Declaration on the Rights of Indigenous People, which acknowledges the need for self-determination and prior informed consent on any decision or actions which will impact First Nations peoples. The value of good administration will be enhanced by including the voices of First Nations peoples, rather than treating them as passive objects onto which the consequences of decision-making may fall. Professor Daly noted of participatory rights generally that greater participation and stronger control over the nature of proceedings leads to greater moral authority of the outcome. Likewise, First Nations consultations is harmonious with the general principle that the greater the impact of a decision on an individual, then there is a greater need for procedural protections to be received. This is not to argue that participatory rights are necessary for legislative decision-making. That exception is well covered in Professor Daly's book. The opportunity for First Nations peoples to input their perspectives into administrative decision-making will ultimately improve the decision when it is made. Electoral legitimacy would also be deepened by First Nations consultations, as it will ensure that where legislation has incorporated an objective related to First Nations people, it will be given meaningful effect. One example I am thinking of is cultural heritage protection laws, particularly in the wake of the Juukan Gorge incident in Western Australia. Decisional autonomy will be accounted for in consultations with First Nations people, in that it does not need to be modelled on the processes used in a judicial trial type procedure. In consulting with First Nations peoples, the decision maker or the reviewer retains their autonomy to decide based upon effective participation. And to focus on Australia for a brief moment, the 4 values identified by Professor Daly, I think, are embedded in the Uluru Statement from the Heart and the reform it imagines for First Nations peoples and Australians generally. Now I want to consider procedural fairness more broadly. Context remains crucial in calibrating the content of procedural fairness. The benefit of Professor Daly's 4 values is that they provide a foundation or a structure to help us guide or understand the review process. Where it may seem that procedural fairness might always turn on individual circumstances, Professor Daly's work demonstrates that at the core, these supremely important decisions are indeed informed by values, if not articulated. The specific content of procedural fairness and the exceptions to procedural fairness will continue to resonate into the future. Issues of notice, oral hearings, cross-examination, rules of evidence, legal representation, and the provision of reasons will arise in future modern administrative decision-making. COVID has provided us with graphic illustrations, how questions which might arise over previously fixed rules about no procedural protections in legislative decisions and emergencies might need to be modified or nuanced. While Professor Daly's book justifiably focuses on the right to a fair hearing and procedural fairness, his values-based approach could be applied to that other great pillar of procedural fairness, the rule against bias. Such is the relevance of bias that the Australian Law Reform Commission is close to concluding an inquiry on that topic. Bias engages the values of concern for the individual rather than reliance on preconceived beliefs or prior involvement. Good administration is upheld when decisions are based on objective material and made in a transparent manner. Decisional autonomy will be achieved when independent decisions are made which are understandable to reasonable observers, free from the influence of others or personal motivations. And to a somewhat lesser extent, electoral legitimacy is also engaged by ensuring that decision-making is not tainted by an apprehension of bias and follows the scheme designed by the elected representatives. Professor Daly argues that both an instrumentalist and a dignitarian explanation can inform procedural fairness, stating that it is not a binary choice between these 2 philosophies. Likewise, he resists the allure of attempting to settle on one overarching meta value as underpinning procedural fairness. Instead, his approach reflects the complexity of our modern society and the individuals within it. The emphasis he places on the plurality of values mirrors the plurality of those legal systems which exist with First Nation peoples. Professor Daly can be seen as having made an important contribution with a fresh framework which adds rigour to the body of law on procedural fairness in administrative decision-making. Beyond procedural fairness, Professor Daly has achieved his 3 goals of making administrative law as a subject more understandable, providing a rationale for its development, and advancing a strong platform of support for the advances made in contemporary administrative law. Thanks, everyone.
Thank you very much, Professor Bedford. We'll move straight to the reply by Dr. Daly, and if there's enough time at the end, we've got 1 or 2 questions.
All right. Well, I do see that there were 2 questions posed by Professor Dixon and John Mark Keyes, and I'll try and cover them off in my reply. So thank you all for your very helpful and insightful comments. I think the jumping off point is going to be Professor Roz Dixon's question about being Dworkinian and what exactly does an interpretive approach or an interpretivist search for? Does the interpretivist have to search for the one best answer, the one best theory? I make a point of saying that I think the current body of administrative law is a legitimate body of rules and principles, not the only legitimate or conceivable legitimate body of rules and principles. I think my approach to interpretation is therefore weaker than a Dworkinian approach, and we might think of a strong versus weak dichotomy in interpretive approaches, where I'm interested in demonstrating that there are recognizably moral foundations without necessarily saying that these are the best possible moral foundations. In part, the difficulty here is where an interpretive approach sits between, on the one hand, a standard doctrinal inquiry, and on the other hand, a fully fledged normative argument about the way the law should be. It is in a constant tension between slipping into doctrinal scholarship on the one hand, where you're just organizing rules and principles in a coherent system, and a fully fledged normative theory on the other hand. And I'm trying to walk a line between the two, and I've tried to be transparent about it. I've tried to be transparent about my objectives, and I hope that I'm not describing the law as it is because of the way I think the law ought to be. I hope I can be absolved. Well, I hope I didn't commit that sin. If I did, I'd hope to be absolved of it. Now, why the slightly weaker approach to interpretivism on my part? In part, it's because I think there's a value to interpretive approaches as opposed to purely doctrinal or purely normative approaches. And in part, it's because of bears. And there's a story that the late Justice Scalia used to tell to justify his fondness for originalism. And he says, look, there are 2 campers in a tent in a national park, and they're set upon by a bear early one morning. And one of the campers rushes off, and the other one reaches for his shoes. And the camper who's rushing off barefoot, he says, why are you stopping to put on your shoes? That's not going to help you to outrun the bear. And the other camper looks at him, he says, I don't need to outrun the bear, I just need to outrun you. And the point for a legal academic is that a theory like the one I've proposed, or the framework that I've proposed, it has to beat the competition. It doesn't necessarily have to be the best possible interpretation. And the competition here, Nina mentioned legislative intent. Those who think that legislative intent is the meta value or abuse of process, abuse of power, as Dean mentioned, these are the contenders, and I need to beat them. And I think I've offered a framework which covers territory which others have not yet sought to cover. Perhaps if there's more interest in interpretive approaches which cover the whole field, I'll need to come back and make a stronger argument again. But for the moment, I think a relatively weak approach to interpretivism is sufficient. It's about as I say, a plurality of values and striking a balance between them. And the last point I would make is about the value of values. I mean, first of all, they can be useful in terms of well, Dean mentioned the accountability function, which I hadn't thought of, but that's a nice additional utility value of my framework. It can guide the further development of the law. I think Narelle has given a very good account of how it might help to guide the development of the law in relation to a duty to consult First Nations. I'd say in response to Justice Edelman and in response to Narelle, it may be necessary to conceive of individual realization as having a group or collective aspect and not simply an individual aspect. And this might be an area where an iterative change to the value is necessary. And I'd say it's also useful in terms of the values are useful in terms of critiquing the law that we have. John Marquise asks me about Canadian administrative law and deference. Using these values, I think if I looked at the Vavilov framework for administrative law, probably on statutory appeals, too little weight is given to decisional autonomy and good administration. We could also, to pick up the bias thread, perhaps critique the High Court of Australia's recent decision in New Auckland, which was about bias and the consequences of bias on the consequences of invalidity. That might be another question to which we could apply the values to critique the outcome reached there. But there we go. Those are my thoughts. I'm very grateful to all of you for having participated and given such wonderful and thoughtful comments and helpful questions. Thank you all very much.
Thank you, Dr. Daly. As I said at the start, it's events like these and a book like this which tackle the deepest and most difficult theoretical issues in law, where academics like our panelists and like Dr. Daly provide such a valuable service to the law. It might even be that ultimately we discover that legislative intention is not even in competition like the two hunters with a role for values, but perhaps they might even coexist at different levels of generality. But thank you all very much for attending, and can I particularly thank the Gilbert and Tobin Centre of the University of New South Wales and the University of Ottawa for putting on such a wonderful event. Have a good day.